I will bet you a steak dinner that this entire hearing will be replayed and analyzed on numerous YouTube channels before the end of the day.
And that's exactly what we're going to do right now. We're going to dive into Kouri Richins' most recent court hearing as the alleged killer mom stands accused of poisoning her husband to get access to his money and then writing a children's book about grief to help their 3 sons cope. We've got major updates for you on some charges being dropped, how jury selection will go, and whether Kouri Richins will be released before trial. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. This week, 34-year-old Kouri Richins was back in a Utah courtroom as her defense team argued several motions in front of the judge overseeing this case, Judge Richard Mrazek. Those motions addressed a laundry list of legal arguments and issues, so we're going to dive into all of them and get a sense of where we are right now in this case. So first, I got to give you some background. Eric and Kouri Richins got married in 2013, and they have 3 sons together. Eric operated a masonry business while Kouri worked in real estate, flipping houses. But you go to March 4th, 2022. And that is when Kouri says she fell asleep with one of their children, wakes up, goes to the bedroom where Eric was sleeping, but instead of finding him sound asleep, she finds him dead, slumped over right on the bed. She said she made him a Moscow Mule before bed, that maybe he had taken a marijuana gummy. But according to police and prosecutors, they say Kouri actually poisoned Eric. His autopsy showed that he had approximately 5 times the lethal dose of fentanyl in his system. The Richins' housekeeper, a convicted drug dealer named Carmen Marie Lauber, had allegedly confessed to authorities that she supplied Richins with 15 to 30 fentanyl pills on 2 separate occasions, approximately 1 month before Eric died, and said that Kouri paid her about $900 each time. And you know what's also really chilling about this allegation and this story? Is that Eric allegedly previously claimed that Richins had tried to poison him on Valentine's Day in 2022. Gave him a sandwich, takes 1 bite, breaks into hives. He couldn't breathe. And that's not the only allegation, because there's another allegation that years before, Kouri had given him a drink while in Greece, and Eric became violently ill. And Eric allegedly told his family at one point, if something happens to me, check out Kouri. Now, this case caught the world's attention when Richins was arrested more than a year after Eric died, not only because of all the details that I laid out, but partially because it was revealed that following Eric's death, she had written a children's book about grief called Are You With Me? She even went on a local news station to talk about it, but again, months later, she was arrested. She was charged with aggravated murder, attempted murder, distribution of a controlled substance, insurance fraud, mortgage fraud, forgery. By the way, this Kouri Richins story, we have been trying actively to constantly be on top of, follow it, provide updates as it develops. And one of the reasons that we can continue to do that for you and make these kinds of shows is because of the support that we get from our sponsors like Upside. Now, Upside's awesome if you don't know what it is. Upside is a free app that gets you cash back on daily essentials like gas, groceries, food. This is real cash back. It's money that appears in your Upside app that you can then transfer right into your bank account. Look here. I used Upside when I went to Dig for lunch, which, by the way, delightful. Claimed an offer on the app, paid with my credit card, followed the steps on the app, got cash back. So easy. I got 20% cash back. And you can use it at all different kinds of places, restaurants, convenience stores, gas stations. So to find out how much you could earn, click the link in the description to download Upside or scan the QR code on screen. But make sure to use our promo code SIDEBAR and you'll get an extra 25 cents back on every gallon on your first tank of gas. But now let's talk about what happened on this hearing on Tuesday. A lot of things to address. So the first thing that I'll mention is that all the parties had agreed to drop some of the charges. They agreed to drop the distribution of a controlled substance charges.
We are here on several motions. I don't have strong feelings about what order to do these in, but I have a proposal, if you'll hear me out for a moment. First, the state's motion to dismiss counts 3 and 4. Ms. Nestor, any objection?
No objection, Your Honor.
And that is without prejudice, correct, Mr. Bloodworth?
Correct, Your Honor.
Okay. State's motion to dismiss counts 3 and 4, which is docket 703, is granted. Counts 3 and 4 in the third amended information are hereby dismissed without prejudice.
Now, no real reason was provided for why those charges ended up being dropped, but I will tell you sometimes prosecutors, they drop charges or agree to drop charges, maybe to not confuse a jury on the issues, or maybe they take out a weaker part of a case because If there's a weaker part of their case, that could jeopardize their overall case, especially a murder case like this. Don't know that for sure, just generally speaking what we've seen in the past. Well, from there, the defense made arguments that some of the charges, talking about them, they should be separated out and addressed at a separate trial. They want the charges related to the Richins' finances, like insurance fraud and forgery. They want that to be severed from this trial. For example, Kouri Richins, she's accused of forging Eric's signature on an insurance application weeks before he died. And Kouri's lead counsel also wanted the attempted murder charge severed or thrown out altogether, saying there's no physical evidence whatsoever that points to Kouri trying to poison Eric on Valentine's Day.
So the slippery slope that you would have to slide down to connect a year prior to something she did in her business to obtain a loan, to somehow connect that to, they've not made any allegations that there was a plan to cause death a year before. There's no allegation that she even had an, they've introduced zero evidence that there was a plan spanning back over a year temporally to her making a decision to take an act in her private separate real estate business that wasn't even connected to her husband. I mean, basically, we would be trying two separate periods of time in history, two totally different sets of witnesses, two totally different sets of exhibits that have zero connection other than the fact that it has to do with money. The argument being that, well, she did it, if she did it before, she must have done it again, right? And so that type of prejudice is just devastating to a defense, and it's based on zero evidence. There's no evidence of it. So to allow I think the 403 almost kind of trumps the 404B argument in this case because of the fact that there is no evidence of this. There is no evidence that Eric Richins on February 14th, that he ingested anything that was given to him by Kouri, that he had a drug, that he had controlled substances in his body, that he himself made statements that he was having an allergic reaction. He took allergic medication. It addressed the problem. And he had a normal day after he took a nap. So to make this leap and say that because he had an allergic reaction on a day 2 weeks before he died means that Kouri Richins tried to kill him is prejudice that we cannot surmount and has zero probative value because there's just no support. There's no support for it. So we would ask that severance be made on the 403 and 404B analysis. We would concede it's probably going to survive the statutory analysis.
So it's an interesting argument, right? Because where do you draw the line for saying two things are connected? When does the length of time between two events come into play?
The court determines that count 1, aggravated murder, and count 2, attempted aggravated murder, are part of a common scheme or plan because they involve a similar fact pattern occurring only approximately 17 days apart. In each instance, defendant allegedly purchased fentanyl from or through Carmen Lauber, allegedly administered it to Eric Richins through food or drink after purchasing it, and allegedly left Eric Richins alone, either by leaving the scene or moving to a different room. Those three circumstances, those three commonalities, are sufficient to determine that counts 1 and 2 are part of a common scheme or plan. The court is not persuaded that counts 5, 6, 9, and 10, that is mortgage fraud and related alleged forgery in June and August of 2021, meet the statutory requirement for joinder. They are not part of a common scheme or plan with the criminal homicide or the attempted homicide in March and February of 2022, respectively. And while the state argues that they are part of a direct relationship or form precipitating events for the attempted murder and ag murder that occurred 9 months later, court's simply not persuaded of that. There is too much temporal distance and too much dissimilarity. They're too different from the events that occurred in February and March of 2022. The court determines that counts 5, 6, 9, and 10 do not meet the standard for joinder under 77-8A-1, subsection 1. Under Rule 404B, evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in conformity with that character. However, this same evidence of a crime, wrong, or other act may be admissible for another purpose, a non-character purpose, such as proving intent, preparation, or plan. The court rules that evidence regarding the attempted aggravated murder on February 14, 2022, particularly in light of text messages that came after that date, in which defendant allegedly texts her paramour to the effect of, "I wish he would go away," or "if my husband would just go away," and on February 26, approximately, in which she contacted her source of controlled substances and stated she needed something stronger. Evidence of the attempted aggravated murder on February 14, 2022 is admissible for a non-character purpose of showing intent to kill Eric Richins and a preparation and plan on how to do so. Given the, in this court's view, connecting tissue of the defendant's alleged text messages between February 14 and March 3, and given the events on March 3, the court rules that the jury is most likely to make findings that the events of February 14 show defendant's intent and are probative of her preparation and plan to kill Eric Richins. The jury is unlikely to draw a general character or propensity-based inference that defendant's the person that tends to kill people, so she must have done it in March 3. Having walked through that analysis, the court denies defendant's motion to sever counts 1 and 2 from each other. Court rules that counts 1, 2, 7, 8, and 11 shall be joined for trial.
I know, that was a lot. So let me break down where we stand right now. So the mortgage fraud and certain forgery charges, they're going to be separated out. Those will be addressed at a different trial. Although I'll tell you, if she gets convicted of the murder charge here, I don't know if they're actually going to move forward with those other financial crimes, but we'll see. But what the judge decided not to do was not to sever the attempted murder charge from the rest of the case. So in the end, Richins is going to be tried next year for aggravated murder, attempted murder, as well as another forgery count and insurance fraud charges at the same time in front of the same jury, meaning out of the 11 charges that Kouri had faced at the beginning of the day, she now faces 5 for this particular trial, which is, again, expected to happen in the spring. Okay, so now let's move on to another issue that was addressed, and that involves jury selection. Very big step in a very high-profile case like this. Now, the number of jurors that are seated in any particular case, that can depend on a variety of factors like state and local rules, the type of case, again, whether it's civil or criminal. Well, Kouri's defense team made the argument that this trial needs a 12-jury panel instead of the typical 8.
We would ask, in a case as serious as this, that we be allowed to seat 12 jurors in the hopes that eventually the United States Supreme Court will determine that to be a fundamental right. I do concede that is not the current state of the law in Utah at this time.
Okay. Ms. Nestor, Ms. Lewis, Mr. Ramos, I took this issue seriously and read the amicus brief and read Justice Gorsuch's withering critique of the Williams versus Florida decision. The state of Utah may be on the wrong side of history on this one. It seems likely that it will be. But when they gave me this robe, I took an oath to uphold the law as it currently exists. And the status, for the status quo of United States Supreme Court jurisprudence is that a 12-person panel is not a necessary ingredient of trial by jury, and a state's refusal to impanel 12 jurors does not violate a defendant's Sixth Amendment rights as applied to the states through the 14th Amendment. Given that pronouncement, which is still good law, notwithstanding Justice Gorsuch's thought-provoking analysis, this court is required to follow Utah law regarding the size of the jury in this case. And based upon Article 1, Section 10 of the Utah Constitution and Section 78B-1-1041B of the Utah Code, a jury in a non-capital first-degree felony aggravated murder case is comprised of 8 persons. I take the motion seriously. I look forward to seeing the law change, but until it does, I'm required to deny it. Defendant's motion to seat 12 jurors, docket 668, is respectfully denied.
So the judge disagreed. This jury will consist of 8 people as well as alternates, but the exact number of alternates seems like that's going to be decided at a later time. And when it comes to jury selection, here's another question. Can it be done virtually? There's been a lot more happening over Zoom and things like that since the pandemic, but does it hinder the attorney's ability to properly question the jurors and see their reactions to questions? The defense argued that there could be issues down the road if jury selection isn't done in person.
Talk to me about constitutional issues first. I had a law clerk look at this for days. We have been unable to find a reported decision in which virtual jury selection, which admittedly has really only existed since 2021, probably, maybe late 2020, has been found unconstitutional. There are 2 decisions. I think it's probably overstating it to say it was found constitutional, but a constitutional challenge was not sustained. Are you aware of any law saying it's unconstitutional?
I'm not.
Okay.
I'm not, and I think you're right. I mean, it's such a new area. We have gone back to in-person in most things.
Not in the judicial branch, though, which is the interesting thing.
It is interesting.
So where the confrontation clause does not apply, we in Utah and many states across the country are doing a ton of work virtually. We amended rules to preserve a victim and a party's ability to request appearance by virtual means. Now, where the confrontation clause applies, doesn't work, right? But the confrontation clause does not apply at jury selection.
That's correct. I don't think there could really be any more extraordinary circumstances than what we have in this case. We are looking at a jury pool, probably from both Summit and Salt Lake, that are going to have knowledge of the facts in this case. Everybody has knowledge of the facts of this case. Having someone on a screen where we can't see them looking at the players in person, where we can't judge what might be going through their mind. It's so much harder to judge someone on a screen when we're asking questions about can you be fair when they are not sitting in the same room as the defendant. It's a lot easier when you're at home in your living room or kitchen with who knows what's going on behind you to say, of course I can be fair, than if you're sitting, right here or in chambers across from Ms. Richins.
May I push you on this a little bit? I've thought a lot about this. Look at this room right now. And with respect, this is kind of a mild version of what this case attracts. There is a television camera behind you in the jury box. I will bet you a steak dinner that this entire hearing will be replayed and analyzed on numerous YouTube channels before the end of the day. Do we honestly expect normal human beings to be forthcoming under these circumstances in person?
I think they're going to be more 2 things. One, yes, I think in person, people are going to be more forthcoming. I don't care if there's a camera in the room. It's harder to say something that is untrue to a defendant's face. Secondly, I think in person, we will be able to judge better if a person is being forthcoming. Maybe they're not going to be as forthcoming, but when you're sitting there in the room with them and you can see all of their body language, then that will be easier for the attorneys to make a judgment call on who should be on this jury and who shouldn't be on this jury. And we're talking about an individual who is charged with the most serious crime an individual can be charged with. That's why I'm making the constitutional argument to preserve the record. And I think that the circumstances could not be more extraordinary. I mean, the reason to do this on WebEx is really for the convenience of the jurors. That's the main reason to do this. And anybody who's picked as a juror on this case is going to be extremely inconvenienced. And if they can't be inconvenienced for the day to come in while we pick the jury, then they're not the people we want on this jury. And that's something else that we can tell when they're in person. The people that fight coming in person, the people that maybe don't show up because it's in person, those are not people that we want on the jury. And we are not going to see that or have that ability to determine that by having them on a camera.
My ability to protect potential jurors from examination, harassment, outside influence, if they're going through the bottleneck that is the front door and the driveway of this courthouse, is zero. I have no ability to protect their identity when they're out there assembling in mass. When they're on screen, I can block the media from attending jury selection, and there won't be any physical opportunity to know who these people are, take pictures of their license plates, watch them come and go.
So in the end, the judge decided that jury selection would need to be in person at the 3rd District Courthouse in Park City.
Given a moment to reflect, the court is persuaded by counsel's arguments that the extraordinary circumstance in this case of the extreme level of media attention requires exposing potential jurors to that circumstance so that they know what they're getting into viscerally and their reaction can be judged in real time. Therefore, the court is granting the motion for in-person voir dire and jury selection. The details of how we're going to accomplish this and whether public access to the jury selection process will be allowed in part at all remain for further consideration.
And the judge also agreed that that jury pool has to be made up of people from both Summit and Salt Lake counties. Now, I have to mention something else that happened during the course of this hearing. It was actually towards the end of the hearing. And this is where Kouri's defense team asked once again for the judge to consider granting bail for Kouri Richins, who, by the way, has been locked up for more than a year. When she was first charged, Kouri was facing the death penalty if she was convicted, but prosecutors later took that off the table. And with that change, plus Kouri's good behavior in jail, the defense was hoping that she could be released with safeguards like an ankle monitor. The defense also argued that it's practically impossible for Kouri to assist in her own defense while she's locked up.
I will say, we have a situation where I believe the amount of discovery we have in this case is now up over, Alex, more than 2 terabytes?
Easily, yeah.
Easily over 2 terabytes of discovery. We have hundreds of interviews, hundreds of thousands of documents. When Ms. Richins is detained, the ability to review and go over that material with her to help her prepare for trial is almost near impossible for us as a defense team. She is a critical part of her defense. She is a very bright, engaged, curious woman who wants to know everything that's going on with her case, as she has a right to. The jail is so accommodating to us, and they make this room available, but it is a room with glass between us. There is no way for us to share documents, to review, to look at videos. And point of personal privilege, there's a little metal stool that I have to sit on for hours and hours and hours to try to go over thousands of documents with my client, and it definitely puts us at a horrible disadvantage. There are conditions that this court could impose on Ms. Richins, including ankle monitor, GPS, house arrest, where she does not leave the home, period, for any reason, where I could go to a place and share with her the documents at a kitchen table, and we could actually prepare for this trial and have a fair shot.
But the judge decided that Kouri Richins needs to remain behind bars, citing not only the serious accusations against her, but also the current state of her finances and the relationship with her 3 children.
Ultimately, the court is not persuaded. While defendant no longer faces the risk of the death penalty, she now faces 2 first-degree felonies, each with a minimum sentence of 25 years to life, in which may be run consecutively, one after the other. As before, the severity of these sanctions, put plainly, of potentially dying in prison, creates a powerful incentive for defendant to harm herself or witnesses in this case, and to flee the jurisdiction of the court. And as before, substantial evidence supports the charge that defendant secured fentanyl and deployed it to kill another person, which is inherently dangerous conduct. Moreover, defendant's relationship to her children and her ongoing real estate businesses were, in June 2023, substantial connections to the local community that mitigated the risk that she would flee. But now, in November of 2024, those anchors have been weakened substantially. The juvenile court has granted guardianship of Ms. Richins' children to members of Eric Richins' family, and through that guardianship, they are limiting Ms. Richins' contact with her children, and that circumstance is likely to persist in some form, even if Ms. Richins is released on bail. Given the extreme consequences that this case poses and the severe negative impacts that this case has had upon Ms. Richins' business and her relationship to her children, the court finds by clear and convincing evidence that there simply are not reasonably available means of mitigating her risk to the community and to herself, or the strong incentive for her to flee the jurisdiction of the court. Defendant's motion to reconsider bail and conditions of release, docket 653, is respectfully denied.
So Kouri Richins is headed back to jail to await her next hearing, a pretrial conference scheduled for December. The trial is expected to begin in April of next year, and we, of course, will follow any developments that happen in this case before then. That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us, and as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.